Hello, everyone. Welcome back to another episode of the UPC Insights. I'm your host, George Walden, and today we're diving deeper into the world of auxiliary requests at the Unified Patent Court. In our last episode, we explored some intriguing cases involving auxiliary requests, and it sparked quite a discussion among our listeners. We received comments and questions that we address today, especially regarding the high number of requests in some cases. So stay tuned as we unravel more insights and discuss the new developments with our expert, wizard, Superman, the man who knows everything about UPC and a good friend of the show, Mr. Tilman Pfrang. Tilman, welcome to the show, my friend.
Hello, George. Extremely funny. Yeah, thank you.
Tilman. So we're back again, and we had some really good questions last time for our last UPC episode. So for those of you who missed it, go back and check out the UPC episode with auxiliary requests from last time, and then also the past shows, which are also great. Tilman, some of our listeners were quite surprised by the high number of auxiliary requests in some UPC cases, over 80 in one case, as discussed in our last episode. Have you seen any new records in this regard? And have we topped 100 auxiliary requests in one single case yet? Now that's going to be good.
Yeah, that's good and interesting. And I have to say, no, so far, at least according to my knowledge, we have not reached the number of 100 auxiliary requests or more.
Okay.
We have to wait for the next episode, I think, maybe in 2 weeks or so.
Right.
However, actually, there is a new case at the Central Division in Munich, or a new decision of the Central Division in Munich, where 57 auxiliary requests were proposed. So
That's
this
getting
is,
up there.
as far as I see, number 2 so far. So the case with the second most auxiliary request, similar to the 80+ case, the Central Division in Munich did not flatly state that such a number is generally too high. So also 57 could be okay. In a preliminary order, though, the Central Division indicated that it gave the defendant the option, they said may identify, until a certain time to narrow down the set of 57 auxiliary requests which were on file. But they did not rule that the defendant must narrow down the set of auxiliary requests. In reaction thereto, anyway, the defendant narrowed the number of auxiliary requests to 12, which were already part of the original set of 57. So actually, they selected 12 among the 57.
Mm-hmm.
The number 12 was then explicitly accepted by the court. And in a certain way, in the end, this case is not only interesting for the high number of requests, but also because it highlights a lot of other things which are highly relevant for our daily practice, such as the UPC's examination duty concerning the granted claims and a lot of other things.
So tell me this, is 57 the new normal? I mean, not 80, but is that going to be the average in between now? Are we looking at 57 as the magic cutoff number that a judge would tolerate, or what would you say?
Yeah, well, in the end, subject to the decision was number of 12.
Okay.
So we know for sure that the court in that case, and also many other cases, will accept such a number.
Okay.
Not a guarantee, though, but there we will have a very high likelihood because we have seen now many cases which were in the region 10 to 20.
Okay.
We do not know yet whether finally or eventually the court would accept a number as 57 or even more than 80.
Right.
Because so far there's no decision where they explicitly at the end of the proceedings accepted such a number. We have only certain indications from preliminary orders and interim proceedings that the number of 57 in that case, or in the other case 84, I think it was, is not generally problematic. So it can work out, but we do not have the magic number. We have a magic range. For me, a magic range is between 10 and 20, or let's say a magic range reaches up to 20. I think reviewing the substantial number of cases we had so far, there were many close to 20 in that region and no problems.
Do you see the possibility that this rule or this openness to have more cases could get abused by lawyers? Say, somebody comes up and says they want to have 22, or not 84, but 120 or something crazy. I mean, the number could go on and on because of a lawyer trying to bring in new evidence, or would that be ridiculous, or is that something that's far-fetched?
A question difficult to answer.
Okay.
I mean, we have a comparable jurisdiction, the European Patent Office, where there's a huge history of opposition cases where also auxiliary requests play, of course, a substantial role. And there's a considerable number of cases where the number of auxiliary requests was exceeding 100.
Whoa, okay. Woo.
On the one hand. On the other hand, I've
Right.
never seen a case exceeding 200.
Okay.
So maybe
there is a limit.
maybe there is a limit, that there's a kind of a limit where a reasonable representative or reasonable party would say, well, above 200 is upfront obviously not acceptable. I mean, you must remember, all proceedings are scheduled in most cases for only 1 day, as well as at the UPC, or both at the UPC and the EPO. And to discuss 200 or more than 200 auxiliary requests in 1 day is not possible. Probably it's also not possible to discuss 100 plus auxiliary requests.
Okay.
Unless they're structured in a way that maybe one and the same objection, if successful, would
open the door for the others.
Or let's say kind of be relevant for 20 or 30 of the 100 auxiliary requests at the same time. So then you can shorten the discussion. This is in practice, you see this very often, that, for example, there's a problem already in the claim set of auxiliary request 1. And because the same problem is also in auxiliary request 2 to 30, the discussion can be very short. Then the opposition division, or in the other case, the UPC central division, would simply state, well, there is one problem. The problem is present in all of your auxiliary requests. So it can be a short discussion. I mean, 30 auxiliary requests would not necessarily mean that you have an individual discussion on every single set of claims.
Okay, that's good to know. Okay, so that's the case. You also reported in your UPC blog, right? Could you elaborate further on this? I think there's so much more insight here for our audience, getting back to what we were talking about with the 57 and 12 claims.
Yes, you can say that. I mean, this is a highly interesting case. Therefore, I've also selected the case from my UPC blog. One, for me, very interesting point was the way of the UPC in that case in dealing with the granted claims after all auxiliary requests failed. So the situation was that they discussed the 12 auxiliary requests.
Right.
And they said, well, none of them fulfills the requirements of the UPC agreement or the EPC. And therefore, we cannot allow any of the 12 auxiliary requests. We can also not allow the full claim set of the granted claims. I have to say the main request was still the granted claims. But normally you would assume, well, they cannot accept the granted claims in their entirety, or they cannot accept the main request. They cannot accept one of the auxiliary requests. Therefore, the patent must be revoked. No. In that situation, they said, well, at least considering the general behavior of the patent proprietor, we do not think that the patent proprietor either wants to have all granted claims or nothing.
Okay.
So, on the contrary, we assume that the patent proprietor is also interested in each individual dependent claim. So that in the end, they examined all of the dependent claims.
Okay.
Finding that none of the dependent claims is allowable, other topic. But for me, very interesting was this additional step of analyzing each individual independent and dependent claim, which is not known at the European Patent Office. They would never analyze each individual dependent claim. They would just say, maybe there's a problem in claim 1, therefore we have to revoke the patent, or there is maybe also a problem in dependent claim 7, maybe because of inadmissible enlargement or something like that. And then they would also revoke the patent in total. They would not look into all dependent claims. On the other hand, at the Federal Patent Court here in Germany, this is a very common practice. So for me, it's interesting to see, again, a parallelity between the court proceedings, I mean, the German court proceedings and the UPC court proceedings. And in contrast thereto, the proceedings at the office, at the European Patent Office.
Right. So I guess my understanding about the UPC patent courts is never say never, because everything seems to be changing. It's always so open. But I
Yeah,
mean,
yeah. I mean, Josh, yeah, never say never. Or I would adapt it a little bit. Never say it will be the same as at the European Patent Office.
oh, very
This
good.
is yeah,
Yeah,
yeah, yeah, yeah.
that's even better. You're right about that.
Hmm.
So it's my understanding correct that the court governs the proceedings and does the work for the claimant. So did you not explain in previous episodes how important it is for a party to be active and present to complete the case from the very beginning? Catchword, our lovely favorite word here, front loading on the UPC Insights.
Yeah, I know that. Therefore, we bring it in every second question. It's fine because and it's good because the front loading is an important aspect of UPC proceedings. And of course, other jurisdiction, other legal systems also know a front loading
Hmm.
procedure, but it is extreme at the UPC. And therefore, it's very good that in every second question you mention the front loading nature.
Right.
And yes, of course, it is and remains front loaded. Therefore, I would not take this decision of the Central Division in Munich as invitation to be lazy. And I mean, the court will anyway look into the dependent claims or something like that.
Hmm.
Absolutely not. It's still the contrary. You must be active. You must present your full case from the very beginning. And in the end, also in this decision, the court actually says, well, we are bound to the requests of the parties
Okay.
and
Okay.
so
Okay.
on. So it is relevant what the parties request. It is of course relevant what they bring as arguments and so on. But in that case, the revocation claimant attacked all claims. So in the logic of the UPC, at least in that case,
Uh-huh.
the claimant also requested to revoke the dependent claims individually, all of them. And also the patent proprietor, on the other hand, brought arguments in their favor, right? And
Right.
therefore, they thought it is their obligation even to look also in the individual claims of the granted claims.
That makes sense. So, well, how do you see this decision in a broader picture? Can we expect that the practice in this case is an example of the standard approach at the UPC? Would you say that?
So far there's not a clear picture. I mean, for many things we have not a clear picture yet at the UPC. But at
Mm-hmm.
least one other case goes definitely in a very similar direction. It was a case of the local division in Munich, I think. So not the central division as the other one, the
Okay.
local division in Munich. And there they said to the dependent claims, yeah, I have not the literal wording,
Yeah.
but they said something like the following. If you defend your dependent claims,
Okay.
but you say as your defense, on the proprietor side, of course, that I mean the arguments you provided for the main claim, for claim number one,
Hmm.
also speak for the allowability of the dependent claims. And if, as in that case, the court finds that your arguments with respect to the main request are not convincing,
Hmm.
then they mirror your approach, or they mirrored, in that case, the
Yeah.
approach of the patent proprietor and said, well, then obviously this argument is not convincing, and we assume, more or less, you do not have any other argument for the dependent claims, and
Okay.
therefore the fail for the same reasons. What I want to say is that this is a very dangerous strategy to say, or just kind of boilerplate,
Hmm.
refer to your arguments with respect to the claim one, because then the court might mirror this approach
Right.
and also more like boilerplate, like say, well, then obviously the dependent claims cannot be allowed either for the
So,
same reasons. And therefore, you can take one from that also the local division in Munich is apparently of the opinion that they have to investigate all dependent claims
okay.
individually. And the second thing is a caution for all proprietors that they should never simply refer to their arguments with respect to claim one alone. Of course, you can do that in addition,
Right. Right.
but
But it's a
you should
risky
provide.
strategy.
It's a risky strategy. You should always provide additional arguments for each individual dependent claim. Yeah.
So, in light of the discussed cases, what advice would you give to a patent attorney and their clients to prepare for potential revocation cases at the UPC?
Yeah, my advice would be to really provide a clear justification or substantiation for each auxiliary request.
Mm-hmm.
It's similar to the previous discussion with respect to the dependent claims.
You're right.
Also, with respect to your auxiliary request, you should never simply refer to your arguments that you brought with respect to the main request in that case. You should always explain in detail what you did,
Mm-hmm.
what feature you added, why you added the feature, and what objections you try to deal with. So again, from the very beginning, when you file this auxiliary request, present also your full thoughts. I mean, I know that this is convenient or easy to say here in our podcast, but on the other, because on the other hand, if you provide a lot of information, the revocation claimant can hold this against you to a certain degree. Then the claimant may say, well, obviously there's a weak point because you thought it's necessary to bring this argument. Obviously,
Yes, I see.
There's the argument to the opposite, obviously. Otherwise, you would not bring that, right?
Right.
But there is not a good compromise. You cannot balance this very well. I would provide any argument.
So you're saying the front loading, you just have to front load everything, and then because the risk of not front loading would open up the door to something maybe being left out that could be used against you. But if you front load with everything, something could be used against you because of all of the front loading.
Yes.
Okay.
Yeah, absolutely.
So finally, Tilman, how do you see the role of the auxiliary request evolving as the UPC continues to develop its case law? Because that's always an interesting question with us, because it's changing there's kind of no rules, but there are rules, if I could say that. Yeah.
Yeah. I would say as the UPC matures, I would anticipate that the nature and practice of handling these auxiliary requests will become more defined and perhaps even also more critical in a certain sense, because I could imagine that we will see in the future decisions where we learn more about kind of an upper limit for the number of auxiliary requests.
Right.
So maybe the one and the other decision might say, well, more than 50, this is simply too much. And then it's more critical because your strategic options are kind of limited. You are limited by a number of 50 in that hypothetical scenario.
Right.
Also, I hope, of course, that we will see a development of more structured guidelines on how many requests can be considered reasonable and how they should be structured. In the end, I hope this kind of evolution we will see will likely result in a more streamlined process that balances the rights of the patent holders with the need for judicial efficiency, of course.
With that being said, I'd like to thank you, Tilman, for joining us today for these comprehensive insights. It's clear that the auxiliary requests are an essential tool in the UPC proceedings, requiring careful consideration and definitely strategic planning. To our listeners, thank you for tuning in. We hope today's episode has provided you with a clearer understanding of the dynamics at play in the auxiliary request filings at the UPC. And join us next time on the UPC Insights for more updates and expert discussions on the Unified Patent Court with me and my friend Tilman and other guests that we'll be having in the future. Tilman, so this is our time now. We can have some fun. Do you know any good UPC patent lawyer jokes? I mean, everybody has lawyer jokes. I think jokes were made for lawyers.
Yeah, imagine a patent attorney dealing with a UPC case, and then the question, yeah, why did the patent attorney bring, in that case, a letter to the court?
Why did the patent attorney bring a letter to the court? Now, there's got to be a million reasons, and funny reasons. I have a really dark sense of humor, but I'm going to let you answer that. Why did the patent lawyer bring a letter to the court?
Because he heard the case was stacked with auxiliary requests, and he wanted to make sure he could reach the top ones.
So I'm thinking we won't be giving up our day jobs as patent lawyers, as comedians, but that wasn't bad. That wasn't bad.
I see you are exploding, George.
Just, oh my God, a ladder to the top. Oh my goodness. Okay.
This needs
Well,
improvement too.
no, we're getting better. So with that in mind, folks, if you have any good lawyer jokes, we'd love to tell them here on the podcast concerning the
better
UPC.
ones, yeah, please.
Yeah, but
Help
I
us.
don't know how good they'll be after that great one that you just told, but we'll see in the future. Guys, thank you for joining us. And if you have any questions or if you're curious about other blogs that we've done or our podcasts, check out our website at meissnerbolter.de or meissnerbolter.com, or go on YouTube or Spotify. We are there for you. And once again, thanks a lot, Tilman, for joining us on this edition of Auxiliary Request UPC Insights. See you next time.
See you next time. Auf Wiedersehen.
Auf Wiedersehen.